Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. Retirement is a time that many of us look forward to and plan for most of our adult lives. But what about planning for what happens after retirement? Oftentimes, we neglect to plan for this next stage of life until it's too late. On today's webinar Wednesday, Attorney Bob Mannor will discuss estate planning, retirement, and what you need to know. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Now, if you do have a general question during today's presentation, please use the chat box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share this with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hey folks, we're going to get right into this, and so let's kind of talk about the main topic here, which is what does this even have to do with retirement? Why are we talking about estate planning and retirement? Well, I think if you have gone through the process of retirement, or if you are getting ready for retirement, that you probably thought about this. There's a lot of getting your ducks in a row, right? When you're going into retirement, it's making sure that we have everything in place, making sure that we're going to have enough money, that we have enough money to pay our bills. One of the things that is sort of a counterintuitive thing is a lot of people actually start to accumulate wealth in retirement. Seems odd, but we've noticed this happen time and time again. Now, you don't want to plan on that. That's why financial advisors are often very keen on saying, oh, well, we got to make sure that you're going to have enough resources in retirement, enough income in retirement. But the thing on this is that a lot of folks end up spending less as they get older. So maybe not in the first few years of retirement, but certainly in the final few years, of your life, that people tend to spend less, and unless they have something that comes up like a long-term care need. So many people will actually begin accumulating more wealth after retirement, which seems very, very counterintuitive. But what does this have to do with it? Well, and we often say, getting your ducks in a row. It's a kind of a common phrase, and just making sure that you have things in place. Here at Mannor Law Group, we talk about it in a couple of different ways. Most people think about estate planning as talking about what happens after you die, right? Well, of course that's important, and even in retirement, like if you haven't done this before, or you did it when the kids were little and you haven't updated it since then, this is the time. Many people start to think about this at the point of retirement or sometime afterwards, because people tend to procrastinate on this stuff. But this is the time to say, okay, yes, I do have to have something in place. What if, maybe we're going to be traveling more, maybe we're going to, have other things, or we're just getting older and we want to make sure that we have things in place, particularly if you're married, but regardless of whether you're married or not. Some people think, oh, well, I don't need to, have an estate plan or a will until one of us dies. Well, that's really not a great idea. It really should be that you're making sure that your spouse is going to be well cared for, that they're taken care of, that they're going to have access to everything, that if one of you gets sick, the other is going to have access. And so it's going to be a matter of not just planning for your death, because that's where lots of folks kind of focus. is I need to do a will so that we know what's going to happen when I die. That is very important. We do want to make sure that we have a plan for what happens when you die. Make sure that your spouse is going to have what your spouse's needs and entitled to. Make sure that, especially if it's a second marriage or things like that, that we planned for the children. But just as important, and in my view, more important, is what happens between now and death. And that's a big part of what estate planning is, okay? It's not just about what happens when I die. That's where everybody focuses their attention, and I think that's the wrong focus. I really think we need to focus on what happens between now and then. And so sometimes you'll hear me say, you know, a lot of times people think about estate planning as what happens when I die. I think about estate planning also as what happens if you don't die. And what I mean by that is it's not that we're not all going to die. We are. However, the issue that comes up is that many of us are going to face some kind of medical need prior to our death. Now, in fact, nobody likes to think about this, but especially if you're starting to think about retirement and making sure that you have, you know, maybe you can plan some vacations or things like that. But the idea is most of us, the majority of us, are going to face some period of time before our death where we might have a medical issue, we might have a memory issue, you know, the rise in dementia and Alzheimer's and all those types of things. And if it's not you, it might be your spouse. And how are we going to deal with those? Well, that's an estate planning issue also, okay? And what we typically don't want is to have to run into court and have a court making those decisions when we've got a spouse, when we've got kids, when we've got family that are more than capable of doing that. You're welcome to do that. I just don't think that most people want that. They want a judge making the decision as to who's going to be in charge, who's going to be in charge of your medical decisions, who's going to be in charge of your financial decisions. And, you know, we can't predict the future. So when we're getting ready for retirement, we want to make sure we're going to have proper finances, but we also want to make sure we have the proper legal documentation in place. But it goes beyond that. So that's just sort of the first level, scratching the surface kind of a thing. The next thing we want to talk about is taxes. Why are we talking about taxes, and what does that have to do with estate planning? And the answer is quite a bit, actually. So there's a couple of different things. First of all, sometimes we imagine that our taxes are going to go down in retirement because we say, okay, well, I'm only going to have Social Security. I'm going to have Social Security and a pension. Well, that's not entirely true because you probably also have a 401k or an IRA or some other assets that are going to generate income. And so then we've got to think about that and making sure that we're being strategic about that, making sure that we decide when we're going to take Social Security, making sure that we have an understanding of how taxes go. Because those that don't do that, what often happens is they go with the default. And the default actually often means that you and your family are going to pay more in taxes. Uncle Sam's going to get a bigger chunk of your money. And why is that? Well, when the biggest thing that we're talking about with taxes and retirement is going to be those retirement type of assets. So like IRAs, 401ks, and those types of things. And so what is a retirement asset? What are retirement assets? And the answer is these are the things that have some kind of tax preference, that the tax code was set up so that you could save money for retirement, and they didn't tax you when you were younger so that you could grow those accounts as, you know, so that you would have some money in retirement. Okay, that's a pretty good concept, good general idea. So things like your 401k, your 503b, if you work for a public institution, IRAs, Roths. We're going to talk a little bit about Roths. Those are a little bit different. But the important thing on these is these assets are treated differently than the rest of your assets when it comes to your estate planning. And it's really important because a lot of attorneys will ignore this. A lot of people ignore this. And so there's two parts to this. One of the things is you're going to be so much better off if you get fairly strategic about when are you going to pay the taxes. So what do I mean by paying the taxes on these accounts? Well, setting aside Roths. So we'll talk about Roths in a second here. But let's set aside Roths. Any other traditional retirement account, a 401k, a PSP through GM, any kind of stock savings program, even things like health savings accounts, your 401k, Anything where you socked away money, it came out before taxes, so you got a tax advantage when it went in, but you got to pay taxes when you take it out. Well, here's where the problem comes in. Uncle Sam's not going to wait forever, right? You understand this. Uncle Sam's not going to wait forever. Just because you didn't have to pay taxes when it went in doesn't mean you don't ever have to pay taxes on that, all right? Now, like I say, Roths are going to be a different category, so we're going to come back to that. But on the traditional IRAs or traditional retirement accounts, 401ks, all those types of things, the idea here is you accumulate it tax-free. It grows tax-free, but when you pull the money out, you get taxed on it. Well, that's fine, especially if you're being strategic about when you take the money out. But there's two things that we have to think about from the standpoint of taking the money out. At some point, they're going to force you to take the money out. Those are the required minimum distributions. Once you turn 72 and some change, there's going to be where every year you have to take taxes out. They call it retired minimum distributions. The other thing we have to think about is what happens after you die, and how is that money going to get taxed after you die if there's money left over? Okay, if there's money in the IRAs after you're deceased, how is that going to get taxed? And that's a really important question. Well, if you don't take money out prior to age 72, and after 72, you just take out the minimums, you may be losing an opportunity to pay less taxes overall, because you might be in a lower tax bracket in some of those years, whereas now when we have to take it out, you have to take out a larger chunk, that might bump you up into a higher tax bracket. So that's really a problematic thing, because it doesn't seem to make sense that you would say, oh, I'm going to pay taxes sooner than I'm required to pay them. But sometimes by doing that, you're actually going to end up paying less taxes overall, because you're keeping yourself in a lower tax bracket. And then the second thing becomes, what if your kids are going to inherit that? Well, whose tax bracket are we going to be paying at that time? It's going to be the kid's tax bracket, each kid individually. Well, you're retired, maybe they're in a higher tax bracket. So it would actually, oddly enough, be better to have it be paid at your lower tax bracket. If your kids are successful, kids are doing well, it might be better to pay some of the taxes, not all at once, because we're going to talk about that, but be strategic about paying those taxes actually while you're alive, and we can pay it at your tax bracket, rather than transferring it to the kids where they're going to pay it at a higher tax bracket. But what about if we're not talking about a lot of money? What about if nobody, you're in a low tax bracket because you're in retirement, the kids are in a lower tax bracket? Why is that a problem? Because when they inherit it, what most kids are going to end up doing is they're going to take that money and pay the taxes. Well, that's problematic, because if they just take all that money out in the first year, that's all income tax. So it's going to put them into a higher tax bracket. So ideally, we're being strategic about how we pay the taxes even after your death, and we can stretch out those payments even longer. Well, again, the IRS has something to say about this, okay? It used to be that the kids could actually stretch those payments out for the rest of their life, just like you could stretch the payments out for the rest of your life. And that the kids, if they inherited your IRA or your 401k, that under the rules, you could stretch those out for the rest of their life. They've changed that for most folks now. And this is where we brought in most of our clients. We put a word out to all of our previous clients, and most of them came in and updated their legal documents to comply with a significant tax law change that occurred last year. The big tax law change that occurred last year is called the Secure Act, okay? So this was passed in late December of 2019. So late December 2019, it passed, overwhelmingly passed. So you can't blame either political party, because they both agreed to this part of it. It was kind of not ideal, because they passed this major tax law change right at the end of the year and had it take effect the next year. It took effect January 1st of 2020. Well, that can be problematic on its own, because the IRS didn't have time to interpret it. They didn't have time. With most laws, the politicians pass the law, and then the bureaucrats write all the rules, right? They write all the regulations and rules related to it. They define things. They make it clear as to what, how this is going to operate, how it's going to be used in practice. Well, the IRS didn't even have time to even think about issuing those rules. So now, we have some of that, but the idea behind this is the law took effect January 1st, 2020. What does that law say? Well, there's a couple of things that affect you during your life. They raise the age before you have to take required minimum distributions. But the big thing is going to be what happens after you die. How are those retirement accounts going to be handled after you die? So the answer is they're going to fall into one of three categories. And I saw this example here, and I thought this was the clearest example I've heard about how are you going to get taxed or seen with the visual about how are you going to how is your money get taxed after you die. And this is specifically traditional IRAs, 401ks, 403bs, not Roths. We're going to come back to Roths in a minute here. Okay. So basically there's three categories. And so this person put it into a stoplight approach. We got red, yellow, and green, right? So we want to avoid the red. Red is that it goes to a non-designated beneficiary. Well, depending on how you've done your estate planning could be that it is considered a non-designated beneficiary. If you just kind of blindly listed your trust, if you have a trust and you blindly list your trust without any proper language in the trust. Now, if we instructed you to put it into the trust, then we would have that language in there. But a lot of people don't have the proper tax language in their trust, but they list the trust as the beneficiary of their IRA or 401k and things like that. Well, in some cases, that's going to be considered a non-designated beneficiary. You see on here, talks about certain trusts, okay? You see certain trusts is on each of these categories. So not all trusts are related equally, right? Not all trusts are going to be the same. A lot of times people, they say, well, I have a trust, you should have a trust, everybody should have a trust. Well, first of all, that's not true. Not everybody needs a trust. But number two, not all trusts are the same. And so when you tell your friends at the barber shop, oh, you should have a trust, well, maybe they should, maybe they shouldn't, but their trust shouldn't be the same as your trust because you got different circumstances, different family situations, different assets. Pretty good chance that they might benefit from a trust, but it's not going to be the exact same. Not all trusts are the same. So some trusts are going to qualify as a non-designated beneficiary, meaning that the kids, whoever inherits your IRAs, are only going to have 5 years to pay the taxes. Most folks are going to fall into this yellow category, and that's called a designated beneficiary. And again, certain trusts are considered a designated beneficiary. Many, but not all of the trusts that we draft are considered would fall into that designated beneficiary. We have drafted trusts for clients that would fall into a non-designated beneficiary. We're not doing those anymore. We're typically only doing ones that would qualify since the Secure Act, since this law change. We're typically only doing ones that would qualify as a designated beneficiary. But some of the folks had chosen a trust that would not be considered a designated beneficiary based on their circumstances at the time. And so the idea behind this is we definitely would need to update that trust. If you got a trust, you better make sure that that's updated and yours meets that standard. That's why we called in. We had an opportunity for every single client that we've ever had. We had an opportunity for them to call into our office for free, or we called them actually, they scheduled the time, so that we could help them determine whether or not their trust qualified as a non-designated beneficiary, and if it did, whether they need to update it to qualify as a designated beneficiary or an eligible designated beneficiary. So if your attorney hasn't done that, if you have a trust through a different attorney and they haven't done that, you might want to have us review it. You might want to have us review the trust to say, is this a non-designated beneficiary trust? Do I need to update it to make sure that my kids have at least 10 years to pay the taxes? Okay. Why is it so important that they have a longer period of time to pay the taxes? Because we don't want to push them into a higher tax bracket. The shorter period of time we have to pay the taxes, typically it means more taxes that we're going to pay. Plus, it means that that we have a shorter period of time for that money to grow. If we have a longer period of time for that to pay the taxes, that means that it continues in that tax-preferred investment longer, meaning it continues to grow tax-free longer. So the longer we can stretch that out, the more money the kids are going to get, and the less money Uncle Sam is going to get. Okay, so then there's this category of eligible designated beneficiary. So what we've done with our trust, when we updated our trust for the Secure Act, this law that changed 2001 or January 1st of 2020, we made sure to include all of the options in there because there's a couple things we don't know yet. If you're alive, there's a few things we don't know. We don't know when you're going to die. We don't know how much money you're going to have when you die. We don't know who your beneficiaries are because those aren't determined until you die. We don't know who's going to be living when you die, right? We don't know if the people that you think are going to inherit your property are still living at that time. We don't know what their situation is. So they might be living, but they might be very sick or in a nursing home or going through a divorce or being sued or things like that. And so we don't know what their circumstances are. So the way we've designed the trust is we said, okay, no matter what their circumstances are, we're going to make sure that they have the option of getting the best tax advantages and the best protection. So protection from nursing home, protection from lawsuits, protection from divorce, all of those types of things. That's how we say, and because we don't know their situation. They might be in a great marriage, they might have lots of money, they might be perfectly healthy, and by the time that you're gone, everything could have changed, right? We know this lately. We know that the world can change pretty dramatically with very little, notice. And so the idea is we've incorporated this eligible designated beneficiary in our trusts so that if in fact one of your beneficiaries, whether it's your children, your grandchildren, somebody else, your spouse, obviously, fall into a category here that we don't know whether they might be disabled. We don't know if they might be considered chronically ill. It's unlikely if it's your kids that they're going to be less than 10 years younger than you, but what if they're not around and it goes to your brother or sister? Obviously spouses, okay? And sometimes maybe we're going to want to bypass the kids and have it go on to the grandchildren, right? And so the idea here is to try to make sure that your trust is updated for the Secure Act so that we have the best possible tax advantages to the kids. Now, before we move on from this slide, I want to talk about the thing that I keep saying we'll talk about that later, and that's those Roths. Well, this is even more important because if you have a Roth or if you're thinking of investing money into a Roth, then this law still affects that, and we're going to talk about that. So what is a Roth? The concept of a Roth is almost the opposite of the traditional IRA. Why is it the opposite? Because in a traditional IRA, you put your money in tax-free, and then you take it out, and they tax it when you take it out. With a Roth, it's the opposite, and it's really interesting because you put money into a Roth that has already been taxed. So you put taxed money into a Roth, and then you never pay taxes again on it, on any of the growth that it achieves. So as you can see, the longer we can have it in there, the more money you're going to have to pass on for yourself, to pass on to your kids, to pass on to your spouse. And if we can keep it in the Roth, if we don't have to spend that Roth money, we want to keep it in the Roth as long as possible, unless we absolutely have to spend that money, because the longer it's in there, the more money we get tax-free. It's one of the rare opportunities that you can have growth in your assets that you don't have to pay taxes on. It's just such a rare opportunity, and the Secure Act deals with that too. But similar to that, we're going to have these three categories: red, yellow, and green. And so ideally, so if it's red, that means we have to pay the taxes within the 5 years. We have to take it all out of the Roth and lose all those Roth benefits within 5 years. 10 years, so what would we do if we didn't need to spend that money in the Roth, which hopefully we didn't? What would we do if we had a 10-year rule? Well, we're going to wait till year 10 because we want it to continue to grow over those 10 years and get 10 years worth of tax-free growth in that 10 years. But what about green? What if we could have it even grow longer than 10 years? Boy, that's a whole lot of money it could grow when it can grow tax-free, and then you never pay taxes on that growth. So if we could fit into the eligible designated beneficiary, that's why we've now drafted our trust to make sure that whatever the situation is, the things that we don't know, we don't have a crystal ball that we can predict the future. So our trust can create all of the options. We can say, look, if we have a beneficiary that would fit into the green category, we're going to make sure that that they have the option to extend the Roth and make as much money tax-free as they can. Okay. Obviously, everybody's family is different, but I want to make sure you have the options. We don't know what the circumstance is going to be at the time of your death. We can't predict that. And guess what? The nice thing about the Secure Act, there's a lot of bad things about the Secure Act, but the nice thing is it makes it easier for us to wait and see and when we have all the relevant data. A lot of times before, families were trying to predict, and they say, well, I think this is going to be the situation. Well, we don't have to do that. We can put all of the options in the trust. And that way, then when we can make the proper decisions, when we actually have the relevant information, when we know when you died, we know how much money you had, we know the nature of that money, whether it was in an IRA, a Roth, not any tax preferred asset. We know who's alive then. We know which beneficiaries. We know what their family situation is. So some of your kids may say by the time they inherit this Roth, or maybe they inherit a traditional IRA, they may say, you know what, me as the child who's inheriting this money, I don't need this money, and I'm in a high tax bracket. I'd rather have it go on to my kids who are in a lower tax bracket, and they can pay the taxes on it, and it still stays in my family. It goes to my kids instead of me. Is that a possibility? Absolutely. We build that into the trust also to make sure that that's an option. And you don't have to make that decision. That's the best part of this, because sometimes parents really struggle over, oh, should I just leave it to my kids? Should I leave it to the grandkids? I'd really like to include the grandkids, but I don't know what the situation is going to be. Well, now you don't have to decide that. We can wait and see. And once we know what the circumstances are, the decision can be made at that time. So whether it's a Roth, whether it's traditional IRA, 401k, things like that, often the best answer is going to be have a well custom drafted trust specific to your needs. I will tell you this, a lot of attorneys have been ignoring this. So this is a really good opportunity for planning and making sure that you pay less taxes. And a lot of attorneys have been ignoring this and just say, you know what, this is kind of complicated. We're just going to keep all of those assets out of the trust. We're just going to keep the IRAs and the Roths and the 401ks, and we're going to bypass the trust completely. That's certainly an option, but often it's not going to get results. The results are not going to be as favorable most of the time or frequently. So keep that in mind. All right. So now we're going to shift gears here, because I've been talking about taxes and people with money, and the more money you have, the more problems you have, or the more tax issues you have, obviously. But now I'm going to shift gears and talk about things for people that don't have tax issues, don't have, maybe you still have lots of money, but what is the real biggest threat for everybody, whether you have a lot of money or a little bit of money? What's the biggest threat in retirement? And this is really the biggest threat in retirement. And it's one that a very large percentage of us are going to have to deal with. So, different times in our lives, there's different threats to our finances. We could lose our job. We could get sued. We could lose our ability to work, right? We could become disabled and lose our ability to work. Well, a lot of those actually lessen as we get into retirement. We're not going to lose our job. If we're in retirement, we're not going to lose our job. We're not going to lose our ability to work because we're not working, right? So while some of those biggest financial threats that we had for most of our lives aren't really a big deal anymore. We're not worried about losing our job. We're not worried about losing our ability to work. Honestly, the statistics would tell us it's less likely that you're going to get sued, and if you are going to get sued, it's because of a car accident, and the car, you have car insurance for that, right? And so your risk to lawsuit liability goes down tremendously in retirement. And so what is the biggest risk? And honestly, it's a big risk that a high percentage of us will face in retirement, and that is long-term care costs. Okay, so most of us are going to face a period of time before we die where we need help. We need somebody else to help us through the day, whether it be helping us get dressed, or helping us make sure we take our medicine, or managing our finances. Or it could be that we just need supervision because we have memory issues, we have dementia, we have Alzheimer's, we have any of those issues, right? I hate to tell you this, I don't mean to be gloomy Gus here, but the majority of us are going to face something like that, whether it be physical restrictions or the inability to make decisions with good decisions, the inability to drive, the inability to handle our finances, things like that. If we live long enough, we're probably going to face that, okay? So why is this such a big threat? Well, because the cost of care, the cost of getting those things handled is very, very expensive. Traditionally, People didn't think too much about this. They said, well, my kids will take care of me. Well, your kids have jobs. Your kids might not even live in the same state as you. The kids might not be able to take care of you. It may get to the point where you need more care than they are able to provide. Or my spouse will take care of me. Well, it depends on whether or not you're wandering away from home at 3 a.m. in the morning. It's really hard for your spouse to take care of you if they're not allowed to sleep, because, you know, and a lot of people with memories, we see this in the news every day, right? We hear about, you know, Mr. Jones is missing, and he left his house somewhere between midnight and 5 a.m., and we're all looking for him, and you see it in the newspaper and on the news and things like that. Terrible stories, and this happens way too often. You probably don't pay attention to it as much as I do, because I help folks that are dealing with that kind of a thing. So that's the biggest threat, is paying for care, paying for somebody to come into your home and provide care for you, paying for assisted living, paying for independent living, paying for nursing home. And so that's one of the things we handle at Mannor Law Group also, is we help folks protect their assets, because there's a number of government programs that if you know how to use them properly, you can protect your assets and still qualify for veterans benefits, qualify for extra Medicare benefits, qualify for Medicaid benefits. There's Medicaid benefits that could pay for home care. There's Medicaid benefits that could pay for, you know, care outside the home. There's Medicaid benefits that could pay for nursing home. All right, but you have to make sure your assets are aligned properly. You have to make sure that your assets are protected, and that's an estate planning issue. This is an estate planning issue that most lawyers don't touch. It is complicated, right? To make sure that you can qualify for these different programs that are out there, and they keep changing the rules on us, it is complicated, and that's why there's only a handful of lawyers that really do this. So most lawyers that did your will or did your trust, they may never have filed a veterans application. They may never have filed a Medicaid application, or if they did, they don't do it on a regular basis, okay? And so it's one of those things that the best situation is to prepare in advance. So if you're thinking about retirement, we should probably look at that and say, hey, if I ever do get to the point where I need long-term care, my spouse needs long-term care, we need somebody to come into the home, we need to qualify for veterans benefits to help pay for home care or for assisted living, we need Medicaid to pay for something like that, or nursing home. Nursing homes can cost $10,000 a month or more. And so the idea would be, can we set this up ahead of time so that we're prepared for that? Just like we're preparing, we're meeting with our financial advisor, we're making sure we have proper income coming in. Well, that's going to be all thrown out if we end up having a $10,000 a month nursing home cost, right? And so the idea behind this is, if you plan ahead, we can make sure that you're going to be protected, or we can at least look for options for you to be protected. And that's a big part of what we do at Mannor Law Group. Okay, so we're going to see if anybody has any questions here, and I'm going to have Savannah give you some instructions about if you feel like this is something that you should have a review. And often we're going to give you many opportunities to have your existing estate plan reviewed, your existing family situation reviewed. Try to create a situation that's going to save on taxes, save your family on taxes, protect your assets from long-term care costs. Savannah's going to give you some instructions about how to get more information.
Thanks, Bob, and thanks everyone else for joining us today. As Bob mentioned, we do have a couple of easy ways for you to get in touch with our team. Of course, you can always give us a call. Our phone number is 810-694-9000. So we're open Monday through Friday, 9 to 5. If you call after hours, you can leave a message. So if phone is your preferred method of contact, by all means, 810-694-9000. Now, if you don't know exactly, or if you're like, I don't have time to call now, but I do want to talk, I've thrown a link into the chat. You can click that link. It'll take you to a calendar. You'll choose a day and a time, and a member of our team will give you a call at a time that's convenient for you. As Bob mentioned, these calls are going to be brief, not very long, but they are informative. We'll get information about your situation. You can ask us questions about our firm, about our process, and you can decide if we're the right law firm to help your family. And the good news is that if for some reason we're not, we'll help you find someone who is. So we're more than happy to speak with you. Again, you can call at 810-694-9000, or just click the link in the chat and choose a day or time. I'm also sending you an email in about 10 minutes that will have that same link. So by all means, check your email. And as I mentioned earlier, Tomorrow, I'll be sending the replay of today's presentation, and our contact information will be there in the email for you as well. So thank you again for joining today. We look forward to seeing you again next week.